we're going to take a little bit of a different spin today. Um, we're going to talk about a couple of things that they come up, and when they come up, I know that we get a lot of questions how to handle these situations, and because they may appear to be more difficult than they really are. So we just want to talk about two things specifically when either buying or selling a property where there's a death or there may be a divorce that's happening. And there are a couple of different avenues that we have to take into consideration when either of those have either happened, or like a divorce, they are in the process of getting divorced, but it's not finalized. And so there's kind of a time period that goes into play. So let's first talk about if there's a death. Now, the first thing that we need to find out is when there's a death that's involved is what type of ownership existed on the property. The most common that we typically see is joint tenants, as you're all aware. And if joint tenants is the ownership that exists, and there's a husband-wife's ownership, and say the husband passed away, then the wife, upon death, this is the one thing that is different. It was different with joint tenants versus tenants in common. Is joint tenants, the transfer of ownership occurs prior to any type of a will, probate, or anything. So once, if the husband were to pass, immediately upon his death, that ownership interest would automatically transfer to the remaining joint tenant. So in this case, just the spouse. It does not require that a will is in place. It doesn't require that it goes to probate. It automatically transfers. Now let's say that you've got, well, joint tenants can also have more than just the two of them having ownership. You can, the most common is a husband and wife, or a couple that have that ownership, but you could have 3, 4 people that own the property together, and if you had 4 of them, each person would have full ownership in the property. And if one of those 4 were to pass away, so there's 3 remaining people, then instead of each person owning 25%, the 25% that existed from the person who passed away, that 25% would be split up among the remaining 3 survivors immediately. So now they would all own a third, a third, and a third. And that would be upon the death of that person. The other part about joint tenants is that ownership must be created all at one time. So in order to get more than one, in order to have the joint tenants work, ownership is established together. You can't have, one person can't sell their ownership of the joint tenants. Well, actually, let me get back on that one. I have to research that. They might be able to do it. I think they actually can. I'll research that. I think they actually can sell an ownership, and then it would remain. I actually don't think they. I'll research that one. I'm sorry, I'm a little bit confused on that one. I don't think they can sell their ownership. Tenants in common, where let's say that you did have 3 people, and they each own a third. Tenants in common, they could sell their ownership to another person, and that can be done at any time. Then on joint tenancy, there's only one deed that is issued, and they each get their own. On tenants in common, they're each getting, sorry, I said in joint tenants, there's one deed and they're each given a copy of the deed. In tenants in common, they're actually given their own individual deed. And so it's a different process. So what happens when, again, when the death occurs and now we're asked to help sell the property? Well, if it's, again, the most common, a couple that one of the parties passed away, then all that we need to get a copy of is the death certificate to show that the death occurred, and thereby the ownership automatically transfers to the individual. So you would provide a copy of that death certificate to the title company, and then also keep a copy of a record. So what would most likely happen when let's say you go to list a property, and the husband passed away a month ago. You've got a copy of the death certificate, and clearly the title, if you were to pull up a title search, more than likely the title will still be in both the husband and the wife's name as joint tenants. Now, they may have already gone to the county recorder and recorded that death certificate with the county recorder, and if so, then the ownership may have already transferred to the full ownership of the surviving party. But if not, we've got a copy of it, and you would just, when you get that listing agreement signed, the owner would be, you would just write the owner in the name of the wife, and they would then sign just themselves. You wouldn't put the name of the owner in the husband and wife as joint tenants, because that tenancy automatically, that ownership transferred to the other side. So it would just be the wife's name, and then the wife's signature is all that would be needed. And then, of course, notify any future buyers. You could even put in the agent remarks that the husband passed away and the wife is the full owner, and the title company has already received a copy of the death certificate, and it's done. If it's tenants in common, this is where things would be totally different. And tenants in common, now it requires a will or a trust or probate to determine who the rightful owners of that property are if there was a death. So you can't just, again, let's say that it was a property that my wife and I own, and we own it, instead of joint tenants, we own it tenants in common, and my wife were to pass away. I can't just automatically now assume that property is mine because I'm the survivor. We have to turn to a will, a trust, or probate to dictate where that ownership occurred. So if my wife and I, we never had a will done or we never had a trust created, then I would have to go to probate to prove that I am the surviving member of that, and before I'd be able to sell it. So in that case, if we are dealing with that type of ownership, then I've got to get a copy of a will, copy of the copy of the trust, or the results from going through probate before I list the property. And we're not expecting you to be attorneys and understand everything that's there, but a lot of this stuff is pretty basic. When you get a trust or a will, it says, hey, in the event of my death, then my ownership will transfer, or the trustee is going to be this person. A trust it walks things through. It'll say whether let's just say that somebody has been legally proven to be unfit to manage their affairs. And so now you've got an attorney, a power of attorney as well for this person. Well, that's something else that you're going to have to take into consideration, is looking at the trust to say, okay, if I'm incapacitated, or if someone has passed on, hold on, let's see, check with your title company. Hold on, someone's made a comment, and I'll look at that in a second. You'll be able to read the trust, and it's typically written in a way that is easy to understand. And you may have a copy of the trust first. Like I said earlier, you'll want to make sure you get a copy to the title company as well. And they'll also help you read and understand what is dictated in the trust. So that makes it a lot more helpful. Let's see. So Julie, check with your title company, but I had to provide an original copy of my father's death certificate before I listed his home last year. Check with your title company first. Saves a lot of time. Yeah, that's exactly right. The title company will be able to help out a lot with that. Don't just eagerly jump in and list the property, and then all of a sudden you're going to have to find that you're going to have to take some steps backwards before you can get anything done. It's a good guide. Okay. Any questions about the death part, even because of joint tenants or because of the death certificates? If a death occurs, it may seem a little bit more complex, but it's actually probably the easier of the two, dealing with death versus divorce. But any questions offhand, specifically dealing with death? Okay, if not, then we'll go ahead and we'll transfer into the divorce piece. Okay, this can be a little bit more tricky, and sometimes can even be a little bit more complex, because we're dealing with a couple of in both incidences, you're dealing with emotion. The loss of a loved one, it certainly can be extremely emotional, and we got to be prepared for that. And then the same can deal with the divorce. And it may be an amicable divorce where the parties are able to get along and they're trying to just make it as easy as possible, and that also makes it easier for you. Or it can be a brutal, painful, angry divorce, and the sides are not wanting to work together, and that makes it extremely difficult for you. So first off, in dealing with the divorce, if the divorce has not been finalized, then both parties still have the ownership, and if they are working together, it's pretty easy for you to, when you send out communication, you either get them both on a conference call, or you send text or emails, and they're both included in the same email, and it gets along, no problem. If it's an angry one, it's a brutal divorce, many times the parties do not want to have any involvement with each other. And the thing that often also occurs is each side of the divorced couple have a tendency to want to use their own realtor. So let's say that Jason is the realtor and he's dealing with a divorced couple, and the husband wants to use him and the wife wants to use somebody else. That is the first obstacle that needs to occur, because you got to get them on the same page. And before you can either take the listing, or, usually on a divorce, they're not going to be in the process of buying a home. So this typically deals mostly with selling the property. So that's the first hurdle, is whether or not you're going to be hired to list the property. So if you do get hired and one of the sides concedes and allows the other to win. So in this case, let's say that the wife conceded her position and allowed the husband to rely upon his choice and hire Jason. Well, Jason's going to be in a tough position right out of the gate, because more than likely the wife is already going to be against Jason, because she's going to think that Jason is on the side of the husband. I want to remind you that we have a fiduciary duty in that situation where both parties are your client. And when one side says, hey, I don't want you telling the other side this, I don't want you telling the other side that. Well, there's some things that part you would be correct. Remember, our fiduciary duty says that we have to abide by what our clients say as long as it is lawful. So confidentiality, for example. Well, confidentiality, there are things that would be confidential as long as they don't apply to both parties in that situation and the sale of the home. So for example, the wife discloses something to Jason that financially would benefit her and financially penalize the husband, where they both eat, and it dealt with something of the selling of the home, and she didn't want Jason to disclose that to the husband. Well, he'd be obligated to disclose that to the husband, because that's an unlawful request that she would have. And so he would have to explain to her that, hey, I am here representing you and I'm here representing your husband, and legally I have to make sure that we're doing both sides. It's almost kind of a little bit, it's not limited agency, but to some extent it feels like it's limited agency. So you're going to have to battle that hurdle. You're going to go back and forth and try to be that counselor almost when you're trying to work with husband and wife. Then there's the next level where, let's say now, because it's an ugly divorce, the courts are now getting involved. And the court has decided that because the husband is being difficult, that the court is now giving requirements upon the husband that if he doesn't do certain things, then he will be, I guess you could say, in contempt of court. And so the court could even, let's say that the divorce is finalized and the court awards full ownership of the home to the wife, and she decides to stick with Jason. Well, even though the court has awarded that ownership to the wife, the husband still will be required to sign all documents unless they did like a quitclaim deed and transferred the ownership into the wife's name and totally removing him from the process. But just because the court has awarded one of the parties the ownership interest, they haven't been awarded full ownership until that has been transferred. So the wife may say, hey, here's the court documents that show that I've got full interest in the property. We don't need my husband's signature on any of the paperwork. That is untrue. That is not correct. You've got to still get the husband's signatures on everything. And if the husband is not playing nice still, then he would be in contempt of court, and he would be then subject to whatever penalty the court would impose upon based on his failure to comply with the court order. So if that were to happen and the ownership was given to the wife, if you can get the parties to agree to transfer the ownership via a quitclaim deed, it'll make your life a lot easier. But if that doesn't happen, you still need to get signatures from the husband. And if he's being difficult, then that's where the wife may have to go back to court to make her husband play nice. Does that make sense on that issue?
So you'd probably want all that taken care of before you actually put that on the MLS, right? So that you're not dealing with that.
That in a perfect world, I would say yes, Jeanette. Sometimes the courts, because they're trying to determine the overall equity in the property to see who gets what, sometimes the court may require that the property is sold before the divorce is finalized, or get it on the market and get offers to get an idea. Because I mean, let's say that we've got a market value of a home of $600,000, and the husband claims that it's worth 800,000, and the wife feels that it's worth this whatever the market value is of the six. And the husband's trying to, if he's going to give up his ownership, he wants the wife to pay him more money before the property's sold based on speculation. So if husband and wife agreed, okay, great, I'll buy the property from you based on an $800,000 price point. And they could do that. They could transfer the ownership, and then the other party would owe $400,000 as half the ownership for as an example, and to walk away. And so to avoid that, they may want to sell the property before they determine, or so they can determine actual numbers. Does that make sense?
Yeah, I guess.
Yeah. Like it would be nice to get it resolved before it's all done, but it doesn't always happen that way. What other questions you guys have about those two scenarios? Okay.
Hey Rob, how's it going?
Good.
Quick question, Jeremy here.
Yeah,
so I've got
Jeremy.
a lead. He just started his divorce process.
Okay.
And from what I know, you probably should not purchase more property during that process before it's finalized. Is that true?
So this is a two-part answer. If I were talking to my client, the way that I would respond to this is, hey, you know what, that's probably a question that you need to ask your attorney about, because there could be some complications that you're going to be facing, and certainly I'm not an attorney to give you any type of legal advice. That would be the answer that I would give. And then between off the record, basically, I would say the reason why if he were to buy property, it's conceivable to believe that, hey, if they're still married, anything that they do is part of the ownership interest. So, and every situation could be different. So we definitely just don't want to give any of that advice. Have them talk to their divorce attorney.
Yeah, and that is what I said. I told him that, go back to this attorney and go over it, because he has a property that he owns that he wants to sell, and he's waiting for mediation to, continue with that process. And he's like, well, in the meantime, can I buy something else? That way I could appreciate equity while that process is going on. And I was just like, you should talk to your attorney about that. It seems like a good idea. However, things could come up. So.
Yeah. I mean, of course you'd love to help him. And another way, Jeremy, that you could show that there's a lot of clients out there that think that we're only in this for the commission and we're out for our own interest instead of theirs. This is a great opportunity for you to just say, hey, you know what, we certainly want to make sure that you are able to maximize whatever profits you're trying to come out from this. And certainly I'd love to help you with that. My concern is if you were to do something like that and it turns out that your spouse did actually get ownership in it as well, that's the key reason why I would advise you talk to your attorney, and right now may not be the right time that you wanted to purchase this until that has been finalized.
Gotcha.
If you talk to your attorney and he says, nope, it's not a problem, and go ahead and look for something, great. Let me know and love to help you. If he says that he recommends that you wait, that's absolutely what I would do. And then once it's finalized, we can talk then and we can help you. Now you're truly looking out for his interest, and you're conveying it that way instead of looking out for your own.
Perfect. Thank you.
Yeah,
Hi,
you bet.
this is Carla Giles. I have a question.
Yeah.
Brand new agent, brand new scenario for me. There's, I think, grandma just died, so the house is occupied now by one of the sons. And last I spoke with her, which is only my second time with the client, speaking with the client, papers have been, the home is in a trust, and
Okay.
the attorney has sent the papers in, I guess, into probate. What is my next move as far as what are some of the documents? What should I be asking for? What should I be doing next? To get copies of, ask for copies. Tell me kind of what my next move is. I know they have
Yeah.
to get the son out, but what should I be asking for? A copy of a trust, copy of the title? What's my next move?
Yeah. So there's great question. Before I did anything, then yes, I would want to get a copy of the trust.
Okay.
And the reason why is because the trust is what is going to tell you, it really tells you your next move. It tells you who the trustees are.
Okay. Yep.
The trustees are the parties that are going to ultimately decide to sell the property and what
Right.
to do with the property,
Right.
and have the authority to sign for in behalf. Now, and the trust could say, hey, these are the parties that decide to sell, and then these are the actual parties that will handle the sell itself. So you could have separate trustees that have different responsibilities.
Right.
The other thing I would, you want to find out, and maybe
I don't even know
the
who the executor is. Yeah.
who the executor, exactly, and that's typically the one that is if it's one or multiple executors, they're the ones that are ultimately the one that are going to be doing the decisions or making the decisions on that stuff. But you'll also need to find out if there's a grandson or son living in the home, do they have kind of a right of survivorship to occupy the property?
Right. Right.
And if they don't have that, was there an actual formal lease that the son signed?
Yep. Yeah, exactly.
And
Now-
if there was, then that lease, whether you sell the property or not, that lease will have to be disclosed to the new buyer, and that new buyer will have to honor that lease.
Exactly. And I don't believe there is one for sure. Now, can
Right.
I get a copy of the title now? Can I
Sure. I mean, well, usually title companies may not offer anything until you've got a signed listing agreement. So you can, now with our listing contracts, what you can do is you can go get the listing signed, if you know whoever the parties are, and then get an MLS exclusion form, which says, hey, it's not going to be put on the MLS until we get all these other matters resolved. But that way you've got the listing and nobody else can go take the listing out from underneath you. And so let's say it's a month later that you've got all these details have now been worked out. Now you can put the home on the market because with that MLS exclusion form, and that form, just so you know, when you get that signed, what that form says is, hey, the party understands that this listing is going to be withheld from the MLS until further notice. So once you get that further, and you need to provide a copy of that right when you get your listing signed, and send that to the MLS, because what will happen if you don't send a copy of that MLS exclusion form to them, when you put it on the MLS a month later, you're going to receive a massive fine for not putting that on within 3 to 5, I think it's 5 calendar days after.
So let the MLS know I have the exclusion form.
You're gonna send a copy of the exclusion form you're gonna send a copy of that exclusion form with your listing agreement,
Yeah, right. Okay.
right when you take it to the MLS services, and they'll just keep record. So that way, when you put it on the MLS, they'll know that, hey, this was done in advance, so there is no penalty, and it'll go
Okay.
right on the MLS. Because otherwise,
Okay.
what agents fail to do is they don't get the paperwork signed, that MLS exclusion form. They take a listing, they go back a month later, oh, I needed this paperwork. And
Right.
that is a violation of the MLS, and they're trying to cover up their mistake.
Now
Well,
the
that's why the
listing,
MLS makes them, that's why they give them the fine.
gotcha. And the listing can be signed by the executor, correct?
Whatever the trust says.
Right. Gotcha.
So,
Copy of the trust is first thing. Okay.
yep,
Thank you so much.
great question.
Rob, I have a question about that.
Yeah,
Why would it be going to probate if there's a trust?
That was a
could-
good question I had.
Yeah, so the trust is it bypasses probate by the trust itself.
Right.
But depending on if they have a will or they have a trust, then yes, probate typically doesn't happen. There may be some extenuating circumstances where it would go there, but if there was something done incorrectly, that might be the only thing. But if there's a trust, then yeah, it's probably not going to have to go through probate at all to get everything moving along.
Right. Okay.
So if I conveyed that message, sorry, that was unintentional.
Gotcha. Okay.
Any other questions about that? Okay, the key part on this, on both sides, whether it be a death or whether it be divorce, just communication. Just ask questions. Don't feel like it's pressured and moving so quickly on one thing or the next. Just move forward. If there are questions that you have, Jason or I are available, or other people are available to try to answer those. But your title company is a great resource.
Sure.
Rob,
Sure.
I have a question, and maybe I'm
Yeah.
making this more complicated than, this is from someone who went through a nasty divorce. So if you go through a divorce and it's really not nice, and you say you get under contract as a seller, and then all of a sudden the other party is threatening, like they're not going to agree to certain things unless you agree to certain things outside the contract, and then the sellers become obstinate, what kind of protection should you write in an addendum when you are in a divorce situation to maybe protect the sellers in the event that both parties don't get along and there's things behind the scene, if you know what I'm saying?
Yeah, I do know what you mean, and in my opinion, unfortunately, the way that you'd have to write it would be something. In essence, you're basically saying, hey, if sellers are unable to agree with one another, then they have the right to cancel this contract. And what buyer is going to want to allow that to happen?
No.
So it's no different than, even if a party's not getting a divorce, if a seller decides to change their mind, and let's just say they're not getting divorced, but one seller just doesn't want to move and the other one does. They change their mind and they can't agree now. They've put themselves in a tough position based on their failure to agree. And so this is one of the challenges on a nasty divorce, that if they don't get this resolved, they're going to both be in default. And like I said, if you know it's going to go that direction, what I would do personally, Jeanette, if that were you, I'd just say, Jeanette, hey, I want to make this clear. If I'm, so far as we've started this process, the understanding I'm having with with the divorce you guys are going through is the both of you are having a tough time agreeing with one another. Before we put this home on the market and receive an offer and go under contract, we need to make sure that we're on the same page, because once you're under contract, you no longer are in the driver's seat. You don't have the right to just change your mind and extend dates, because if you do, you both are going to be potentially at risk. And so if you guys cannot commit to working together to get the home sold, then it's probably something we should wait until the divorce is finalized before you sell this.
That's perfect. Thank you.
Does that make sense?
Yeah, thanks.
Emily, I'm not sure if you asked that question before. She may not even be on the call anymore. Oh, no shit. You asked, hopefully with Lisa asked the question about the probate, having the trust. I clearly must have conveyed that message. So hopefully that's now not confused. If you've got a trust in the will, that should take care of needing to go to probate. So if you don't have those, that's when it's going to be more required.
Thanks, Rob. That answered the question. I appreciate it.
Okay. Any other questions about this? Okay, if not, then.
I don't have a question. I have a statement.
Okay, sure.
Over the years, I've dealt with people that have trusts and a death, also the probate situation. And just to encourage people, especially new agents that are approaching that, is they need us more than ever. It's a rough time, and probate is not pretty, and it's expensive for people, and they need somebody to lead them through that as a real estate agent. So I would go after it with everything, because at the end of the day, they need us. They need us more than a regular sale in my mind. So
yeah, that's
just
great
a little bit
advice.
input.
And what I'll just add to that, when we are asked to wear multiple hats in our job, I just want to remind you the key thing, what we are hired to do. And we are hired to market and help facilitate the sale of their home. That's the hat that we wear. And what I mean by that is, one of you may have a general contractor's license, for example, and they're asking advice, and you start giving your advice that would fall under a general contractor's license. Well, you got to be careful. You're hired to sell their house, not hired to. If you're going to be giving them general contractor advice, then that needs to be a separate business dealing, where you're going to be sending them over a contract, and they're going to represent you as a general contractor. Now, maybe it's a conflict of interest of doing both, but it's just a reminder, you're hired, which hat you're wearing. We run the risk of, I'm dealing with a situation right now where we try to give some advice and help out a client that was outside of what our job was, outside of our licensure, and it's potentially causing a legal battle. And so we've got to just remember what our hat is. What are we hired to do?
Rob, this is
Yeah.
Emily.
Yeah.
So I've read a little bit about the probate stuff, and where I found the information, just if anybody wants to go into it, the Utah Courts website has some great information about how that runs if you
Oh,
don't
perfect.
have trust or a will. So I've looked at it a little bit. It's been helpful to understand the process and to give that resource to your client so they can do the research themselves.
Yeah, what I would say is this. I would first say, hey, you may need to talk to a probate attorney. At least, here's this website to help answer some questions you may have, but definitely you need to consult with whoever you believe is going to be able to provide you the answers to your questions. Thank you. Appreciate it, Emily. Anything else? We got Greg over there. Looks like he's stressed about this matter. He's over there just wondering, how do I handle it? How do I do it? But he's good. All right. Well, if there's nothing further, then we'll let you guys all go and enjoy the rest of your Tuesday. Thanks, everybody.
Thank you.
Thank you so much.
You bet.
Thank you. Have a good day.
You too.
Yeah,
Bye-bye.
thanks so much. Appreciate it.
You bet.